So hi everyone, and thank you very much for your patience. I'm delighted to be joining you, and thank you for the invitation. And I'm going to follow on and hopefully not duplicate Elspeth's presentation, but I think already it raises a number of questions that will be relevant also to some of the comments I'm going to make, and hopefully to our discussion at the end. I'm going to fly through these slides pretty quickly. I want to just introduce some ideas, some ways of thinking about whether or not we're making progress in legal responses to human trafficking in terms of conceptualizing human trafficking as a serious human rights violation, but also in thinking about more effective measures for prevention, for access to justice for trafficked persons, and as Elspeth said at the end, rethinking the relationship between trafficking in persons and borders. In the online world, that is particularly relevant at the moment, but I think as we've seen also, the whole question of how borders constrain possibilities of movement, access to remedies, increase risks of exploitation, these continue to be concerns. So in recent years, we've seen what some have referred to as the justice cascade in other contexts, borrowing from Catherine Sickink here. We've seen a proliferation of new legal instruments and soft law around trafficking in persons. The ILO recommendation and protocol on trafficking in persons, the ASEAN Convention, which is now in force, the draft general recommendation from CEDAW, which focuses in particular on the global migration context, and significant developments in proposals around monitoring procedures and mechanisms, including the review mechanism of the Palermo Protocol, discussions around 20 years of Security Council Resolution 1325, and developments in terms of the Council of Europe, GRETA, the group of experts, its processes, and more globally trying to think about responding more effectively to this challenge of ensuring accountability. So as the majority of you are scholars and researchers and thinking about trying to probe these questions more deeply in the academic world, I think what we have to think about is whether this proliferation of international instruments is having or can have a jurisgenerative effect, as to borrow from Sheila Benhabib's work. So challenging power, challenging the kind of borders that constrain a human rights-based response, and thinking about, as she says, new forms of justice. And in thinking about human trafficking, particularly in the Council of Europe context, building on the Anti-Trafficking Convention, we tend to speak quite easily about human rights-based approaches and a human rights-based response. So moving beyond the limits of a criminal justice response. But it's not always clear in practice what that means, or even in terms of legal concepts. And so on the one hand, we see this kind of normative recognition that trafficking in persons is a serious human rights violation and repeatedly condemned by states, by courts, by regional bodies. At the same time, we see this process of juris pathos, of de-juridifications, of exceptions, exclusions, and limits that may be in relation to particular areas or realms, agricultural sector, fisheries, domestic work, where there are difficulties in terms of expanding the scope or reach of legal instruments. Or it may come at the point of borders, where we see questions around whether the migrant herself is somehow culpable in terms of her own conduct. So on the one hand, recognition of a serious human rights violation, on the other hand, constant exceptions and limits. So we have this kind of risk of double jeopardy, law's dual role in controlling borders, particularly in the context of immigration, the constant reassertion of state sovereignty and states' rights to respond to what is seen as irregular migration, We have questions as to who is the proper subject of law's protection. That can be relevant, as Elspeth said, of course, in the online world. Who is the victim? What jurisdiction is she in? What laws apply? What rights to assistance and protection? And where does state responsibility fall, or where do the obligations of due diligence bring us? And constantly in the human trafficking world, at international level, at UN level, in working with UN agencies, in working within ICAT, and also at European level, you have this tension between a so-called egalitarian logic, the human rights-based response, versus the police logic, the crime control, the criminal justice response, the border control response, and this reliance on criminalization as a policy means in the context of anti-trafficking initiatives. There's also the question of to what extent are our anti-trafficking laws having an impact in terms of prevention on the one hand, and on the other hand in terms of access to justice, effective remedies, rights of assistance and protection, including rights to stay. Or do these legal norms play what I've called there a kind of a kettling role, confining political claims around the rights of trafficked persons, the rights of migrants, access to justice, to predetermined legal forms, and that can be constraining. There's also the concern, and I know certainly from my experience within the Council of Europe and UN level, that there is a lot of sensitivity to moving beyond stereotypes. This risk of the victim of modern slavery, this excitement by the exotic, the constant reference in imagery to injured subjectivities, to the trafficked person as a victim in need of protection, and this constant re-emergence of protective norms. It's something that my predecessor, Maria Grazia Gianmarinaro, was very concerned about, particularly in bringing survivors and bringing those who had experienced as victims or survivors of trafficking, playing a leading role in determining responses and shaping those. But we don't always see that in practice on the ground. We see very limited evidence of that kind of practice. There's also the question of bringing us into the migration realm. Again, when we bring human rights claims into questions around borders, the rights of states tend to overshadow the rights claims of individuals. So where does that leave us with this kind of proliferation of legal instruments on human trafficking? Is it a progress narrative in terms of the expansion of these legal instruments, the expansion of a body of jurisprudence at the European Court of Human Rights, at national level, growing attention by the treaty bodies, CEDAW's new general recommendation, individual communications pending before the treaty bodies, and an expansion of judgments at state level as well. So does that raise the possibility that we can move beyond the limits imposed on us by what was shaped in a criminal justice framework with constant limits with regard to migration? Or will we constantly hit up against those kinds of barriers? So just to look at some of the developments that we have seen, and then to return and perhaps throw those questions out to you. You've all looked at the Global Compact on Migration, the specific objectives on trafficking, where it's quite laudable in terms of the promise and the aspiration, in particular around protection and assistance, measures for physical, psychological and social recovery, including measures to permit victims of trafficking to remain in the country of destination, of course, with the compromise that that may be temporary. But nonetheless, it's continually trying to move beyond what we had in the Palermo Protocol to build on the recommended principles and commentary of the Office of the High Commissioner for Human Rights and the Global Plan of Action. So there is this push, but the practice on the ground, as we know, particularly around unconditional assistance and protection, remains weak. We've seen significant judgments building on RANSF at the European Court of Human Rights. But here again, if we look closely at what RANSF, the statements of the court there around regulating businesses used as a cover for human rights, really probing states' immigration rules around facilitation or tolerance of trafficking. Too often what we see there is what Diane Otto referred to as this kind of injured subjectivity, this concern around the need for protection, leading to a response that controls or curtails the rights of migrants, including trafficked persons, rather than looking at a response that would see an opening of regular migration routes, greater regulation of socioeconomic rights, of labour rights, as being appropriate remedies and responses to human trafficking. So again, these positive obligations that are signalled in practice, it is limited in terms of the response that we see. Again, Chowdhury was an important judgment, had a particular impact in Ireland, where I'm based, in relation to the work of the International Transport Federation and the fisheries industry, and the Irish Human Rights and Equality Commission. The National Human Rights Institution was an amicus in those proceedings, which were settled. But that initiative very much drew on the judgment of the court in Chowdhury around the right to an effective remedy, the failure of the state's obligations in relation to identification, non-punishment, the irrelevance of prior consent, and the application to a different context, primarily men, in a labour exploitation context, also then extending into the fisheries realm. We've seen at Council of Europe level much greater attention to labour exploitation, to trafficking for the purpose of labour exploitation, and that has been taken up across the Council of Europe, also in the work of the Office of the Secretary General, and in GRETA's prioritisation of identifying good practices or promising practices in responses to labour exploitation. There's also been a focus on the role of civil society in giving assistance to victims, but also in identification and access to protection. And this is in the context of increasing criminalisation of human rights defenders working with migrants. And that is something that has been taken up also at UN level by the UN Special Rapporteur on Migrant Rights, and in the work of the SR on trafficking. So again, that goes to core issues around the rights of trafficked persons, protecting that civil society space. GRETA itself, the Council of Europe group of experts, has been innovative in terms of developing its monitoring procedures to be more responsive rather than the somewhat lengthy reporting process every 4 years, which, as we know, has its limits in responding to a specific situation. So it has used its urgent procedure process in relation to Hungary and the transit zones, and also in Italy. In Hungary, one of the questions that arose in relation to the transit zones was whether or not possible victims of trafficking were being detained in the transit zones. Was this a place of deprivation of liberty? Were there questions around people being pushed back to Serbia across the border? We were told that people were free to leave in the direction of Serbia. That was the terminology used in the government's response. As we know, we had initially a promising judgment from the European Court of Human Rights Chamber judgment, which was then overturned by the Grand Chamber. GRETA's report on the urgent procedure visit had highlighted the transit zones as a place of deprivation of liberty and a place where people seeking asylum who were also victims of trafficking should not be sent. Concerns were also raised around what was seen to be practice of refoulement and the state's failure to comply with its obligations of non-refoulement. As we also know, we then had the situation where the Court of Justice of the EU took a different direction and a more rights enhancing or rights protective approach to the transit zones, seeing these as places of detention. There's also then been the concern around collective expulsions and refoulement obligations. Again, looking at the Grand Chamber in ND and NT versus Spain. And this was the judgment that GRETA, the group of experts, had also drawn upon in several of its reports, and also in relation to the urgent procedure visit to Hungary. The pushbacks in Ceuta and Melilla, and as we know again, the Grand Chamber judgment deferring, however, to what they said were states' rights to take measures against quote-unquote foreigners circumventing restrictions on immigration. And you had the bringing in of these questions around own culpable conduct. So again, within the court's jurisprudence itself, a pushback against these rights protections that had been slowly and incrementally developing in some of its jurisprudence. So again, this idea of exception and exclusion. The urgent procedure visit in Italy, this draws on GRETA's innovation in relation to its own rules, Rule 7. So it was something that's developed internally, but was not challenged or questioned by the Committee of the Parties or the Committee of Ministers. And it is where there can be a response that requires immediate attention, where reliable information is received. Italy's questions arose there from communication correspondence to the group of experts in relation to forced returns, in particular to Nigeria, and in relation to the conditions in the so-called hotspots, particularly in relation to unaccompanied and separated children, and specific communications around removals, forced removals from the detention centre, the Ponte Galleria outside Rome, and a failure to comply with pre-removal risk assessment requirements. These concerns were raised again in the second evaluation report of Italy, where at that time attention was also given specifically to the role of civil society, to the rights of search, rescue and disembarkation, and need for greater attention to assistance and identification. These are just some of the recommendations coming from those visits, and I'll move through them quickly in the interest of time, but they'll be available if you want to look through those. The non-refoulement obligations were also highlighted in particular in the second evaluation report. And again, this was drawing on the European Court of Human Rights jurisprudence as it was developing at the time, as well as UNHCR guidelines. And the saving clause of the convention specifically on obligations of non-refoulement. These concerns and questions around pushbacks, their potential application to trafficked persons has been repeated in several GRETA reports. Broader concerns around the rights of migrants and refoulement obligations in so-called pullbacks, and I see that Noemi Magugliani is participating, and Noemi has been working closely with GLAN, Global Legal Action Network, on strategic litigation in relation to so-called pullbacks. And all of these, although they're not specific to trafficked persons as such, I think much more work needs to be done in relation to how non-refoulement obligations apply with regard to victims of trafficking, potential victims of trafficking, and the rights on return, and to what extent the pre-removal risk assessment is really looking at risks of trafficking on return or re-trafficking. This was something that came up quite a lot in the GRETA first visit and evaluation report on Turkey, where there was serious concern. GRETA uses the term urge, where a breach is identified in relation to compliance with the non-refoulement obligation and returns without appropriate pre-removal risk assessment from detention centres primarily. Also there, the group of experts raised again the questions around the role of civil society, particularly important in relation to access to removal centres, provision of legal assistance and advice, and also being involved in identification. But as with the Hungarian context of the transit zones, there was serious concern around who had access, which organisations, which civil society organisations, whether legal aid was being provided, and whether that was also being controlled in terms of access. So again, these human rights norms, human rights obligations, drawing on the broader human rights framework being incorporated into this monitoring and assessment. To move on and just quickly then to finish up and to highlight some of the ongoing areas of work, I think certainly for the UN Special Rapporteur mandate, and more broadly in terms of gaps in research, new areas of research needed. The Special Rapporteur's mandate in recent years has really tried to break down the silos and compartmentalization of different parts of the UN system, different parts of the international community. So looking at trafficking in persons as part of the Women, Peace and Security agenda at the Security Council, but also looking more broadly at trafficking in persons in conflict situations. That is usually considered and reflected upon in relation to sexual exploitation, in particular targeting of women and girls. But as we know from reports from Libya in particular, as we know from the engagement of the International Criminal Court in relation to the situation in Libya and crimes of enslavement potentially, greater attention needs to be given to the gender dimension, to men and boys, and to other forms of exploitation. Looking at the various submissions, and they're really lengthy submissions to the general recommendation, to CEDAW's draft general recommendation. The submission, for example, from the Special Representative of the Secretary General on sexual violence and conflict, raises the possibility of trafficking for the purpose of sexual exploitation or other forms of exploitation in different settings, including, for example, around mining areas, linked to extractive industries, linked to situations of humanitarian crisis. So again, this is, I mentioned here the Women, Peace and Security agenda, but it's also something we need to think about in terms of breaking down that compartmentalization that international institutions and organizations and their ways of working and the different legal frameworks impose upon us. So some of my initial work as Special Rapporteur and building on my predecessor's work has been to link into the global protection cluster of UN agencies working in humanitarian settings, trying to build capacity and awareness and better practice on the ground to identify and recognise trafficking as it is occurring, but also to be more effective and timely in prevention. The annual reports of the Secretary General on conflict-related sexual violence are also very useful. And as I've noted there, we have seen a number of Security Council resolutions that are important and could usefully, I think, be given more attention in terms of research and reflection and impact on the ground in these settings and in the take-up and practice by humanitarian actors, peace operations on the ground, and also in the context of forced displacement, internal displacement, and refugee settings. So again, although it may seem obvious to all of you here working in the field, in practice on the ground, we see that these are often really compartmentalized and limited, and trafficking tends to be seen as a highly specialized criminal justice question, but not something of broader relevance to humanitarian settings, to aid and development agencies, to disaster responses, or to even conflict situations. And so finally then, to note some of the work that's been done in setting an agenda around next steps on human trafficking. Elspeth mentioned the work of ICAT, which brings together a very large number of organizations, and that's a good thing in terms of coordination. It also has its challenges in that it can be more difficult to get agreement or slower to move forward. And sometimes if you're operating by consensus, you don't always reach the highest standard that you might want to. But nonetheless, it's that tension between trying to enhance and increase participation and coordination, but always trying to strengthen and deepen the human rights norms underpinning the work. The resolution of the Human Rights Council adopted at the end of July, which renewed the mandate of the Special Rapporteur, is very detailed, very comprehensive. If you compare it to earlier resolutions, you can see the impact of the work that was done by my predecessor, and interestingly, about 100 states actively supported and engaged with the resolution, but quite a lot of detail in relation to supply chains, labour exploitation, access to effective remedies, and the non-punishment principle. So really pushing beyond the limits of a criminal justice response. I think we also need to, in terms of reflecting on where we are with human trafficking, law, practice, policy, academic research, to think of the underpinning racism that we see in responses to human trafficking, and to think about the context of global migration law, and to think about that in the context of decolonization moves, and to what extent patterns of labour exploitation and sexual exploitation are being replicated in new ways through so-called labour externalization programs, for example, from East Africa to the Gulf, in the deregulation or very loose or light regulation of certain sectors, or in the continued use of perhaps not tied visas as such, but visa regimes and migration entry routes that make it difficult, difficult for migrants to assert rights to be protected from exploitation, therefore heightening risks of trafficking. And I had started looking at some of the work of Ben Habib on rights and jurisgenerative responses. So Ben Habib, of course, draws heavily on Hannah Arendt's work. So just closing with a reference there to Aisha Chubukchu's work on Arendt, race and lawbreaking, to think about the underpinning potential racisms that we see in responses to human trafficking. And to note the work that needs to be done, that has been ongoing just last week with UNODC, with the working group on trafficking, with ICAT, around non-punishment. And I think this is an interesting one in that it really highlights the tensions between the criminal justice response and the human rights-based approach, where the right of a trafficked person not to be punished for criminal activity or other legal violations, including immigration, for example, and the criminal justice response needing requiring impunity or combating impunity for certain crimes. And the Special Rapporteur on Trafficking issued an important position paper at the end of July on non-punishment, which really tries to emphasize the obligations, the positive obligations on states to ensure adherence to the non-punishment principle from a very early stage. So not just during prosecution proceedings or at the point of sanction, but ensuring that trafficked persons are not prosecuted, so that they are identified early on and protected from criminal sanction or other sanctions. And this has been, of course, particularly controversial in the context of forced criminality, in apparent links with crimes of terrorism. I just posted there the reference to the Shamima Begum situation, and that just highlights and brings into perspective, I think, these tensions between obligations of identification, access to protection, non-punishment, the rights of a child, and then the kind of rush to panic in relation to terrorism, so-called foreign terrorist fighters, and a neglect of the question of whether there is forced criminality. And I think there will be interesting work coming forward on all of this area in the near future. So I think there's plenty of work and research that could usefully still be done in this field. So thank you very much.